Estate Planning Counsel Mitch Mitchell is here answering your wills and trust questions and things of that nature. All right, here's the first question we got. If I leave everything to my nieces and nephews, is there any way to make it ironclad so that no other family members could potentially contest my will?
That's a good question. It's a question that a lot of people have, I think, is how can I sort of mitigate the possibility for disputes? And that's one of the downsides of the probate process is it has a design to make sure that anybody can come forward and have their say and say, no, I was left out and I shouldn't have been. And so one way to sort of mitigate this problem is to have a very clear plan and make clear, here's what I'm doing, here's why I did it, and make it not be a surprise to the family either. Don't let it be the first time that they're hearing about the plan when you're no longer here. Maybe discuss with the family members you think are going to be disappointed, here's why I'm doing this. That is one way you can address it.
So when you said make it very clear in there, do you say like, I want all my assets to go to my nieces and my nephews, they're really in need, my other family members don't need this kind of stuff, that kind of thing?
That kind of thing. You don't necessarily have to have a narrative in your will about why you're doing it. I think a lot of attorneys would eschew that. But I think explaining to people, here's what my will says, especially your executor, the person who's going to be carrying it out. Here's what I'm doing, here's why I'm doing it. But explain to the family members that are benefiting, or maybe the ones who are going to be disappointed separately, that here's what I'm doing, here's why I'm doing it. And, that coupled with a clear plan explaining what you want to happen can help head off disputes.
All right, this person says, can you just write a simple will? This person is executor and will handle all the monies and sale and care of my home.
Yes, and fundamentally, that's what a will does. It says, here's who's in charge, and here's who I want to get my property. And there's no reason really for a will to be complicated, but it can be a complicated document if you want it to be.
Okay, this person says, what is the simplest way to make sure my mother's home is split evenly between me and my two brothers?
So there are several options there. One is for mom to make a will saying that she wants the property to be split amongst the three sons. And another way is just for her to make a lifetime gift, or maybe, I don't know if North Carolina recognizes transfer on death deeds, but some jurisdictions allow that, where you can name beneficiaries in advance and say, when I die, I want these three people to get my house.
Okay. What is the difference between a living trust and a testamentary trust? Am I saying that correctly?
Yeah. Yes. So a living trust versus a testamentary trust. And a living trust is document I set up while I'm alive, and I transfer my assets into that trust it's one of its main features is avoiding probate. The testamentary trust is a trust created in my will. And so it doesn't come into effect until my will has been probated. It's been filed with the probate court and accepted. But it also allows me to place conditions on what happens to those assets, because the default for property passing under a will is it goes to that person outright. But if I have beneficiaries who are minors, for instance, maybe I don't want that property to go to them outright. I want a trustee to manage it for their benefit. And I can do that in my will by creating a trust, and that's called a testamentary trust.
Okay. This person says, we have wills completed in Texas. Are they enforceable in North Carolina?
So this is a great question. I like this. I am in Texas, and I do know that in Texas we have a law, and a lot of states do. I'm not sure if North Carolina does, but it probably does, that says if I've created a will in one state while I was physically there or a resident there, it's still valid and treated as valid and can be probated in the court there. So in Texas, we can do that. The opposite could be true, where I have a North Carolina will and I move to Texas and I die in Texas without having made a Texas will. It's still recognized by the Texas court as a valid will and can carry out my wishes for my property and who I want to be executors still.
Gotcha. Okay. All right. We've got one last segment where you can ask your questions. Right now, we're going to take a quick break.